Can super producer Dr. Luke sue superstar singer Kesha for defamation? To find out, you have to read Gottwald versus Sebert, but it's 41 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, Court of Appeals cases that I try to cover in 5 minutes or less. This is the episode on the case of Gottwald versus Sebert. This can be found at 2023 New York Slip Opinion 03183, published by the New York Court of Appeals on June 13th of 2023. The issue in this case is the civil lawsuit of defamation, what privileges may apply, and the retroactivity of the SLAPP statute for defamation cases. And I'll get into all that in a few moments. To set the table here, the law you have to understand before we talk about the facts and the holding in this case is what defamation is. First, defamation is a civil action in which the party, the plaintiff, claims that the defendant has made a false statement that causes reputational or character harm to the plaintiff. There's some elements generally to defamation. The elements generally are the defendant made a false statement, published to a third party that was not privileged or authorized. The defendant was at least negligent and possibly acted with actual malice. I'll explain that in a few moments. And that this false statement caused harm, or it doesn't even have to cause harm if it was defamation per se. Defamation per se is essentially, New York has recognized that there are certain subjects that a false statement automatically is presumed to cause harm. And the four types of areas where it's presumed to cause harm, you don't have to actually prove harm. It's when the statement charges plaintiff with committing a serious crime, statements that tend to injure another person in their trade, business, or profession, statements imputing a loathsome disease on the person. Say if you said the person has polio or AIDS or some communicable black plague, whatever it is, and statements that impute unchastity on a woman. Those are the areas that are defamation per se, where it's presumed to cause harm. And finally, to set the table, you have to understand a little bit about what the SLAPP statute is. The SLAPP statute has an acronym. It stands for Strategic Lawsuits Against Public Participation. Essentially, there were statutes that were, this is designed to protect First Amendment exercise. So it's designed to protect people from getting sued frivolously as a consequence of them exercising their First Amendment rights to express themselves or speak on matters of public concern. We'll get into a little bit more about that in a few moments. What are the facts in this case? The facts are that there's two parties here. The plaintiff is named Lukas Gottwald, otherwise known as Dr. Luke, who's a famous music producer. And the defendant is named Kesha Rose Sebert, and her famous singing name is Kesha. So there's Kesha and Dr. Luke. And Dr. Luke basically owns several record labels, and in 2005, he signed up Kesha to work for his record labels and produce albums together. They made several deals. They produced several albums. At some point, Kesha tried to get out of their deal, and Dr. Luke wouldn't let her. They released several albums that were very commercially successful, making Dr. Luke millions of dollars, making Kesha millions of dollars. In 2012, Kesha again tried to renegotiate. Dr. Luke refused. And in 2014, she filed a claim in California. So it's a California lawsuit looking for rescission of their deal. And she claims in that California lawsuit, and she claimed in official court papers here, that Dr. Luke raped her in 2005, shortly after he signed her up as one of his artists. And she sought damages and an injunction voiding the contract, voiding their agreement. Dr. Luke then files in New York, this is the case that we're dealing with now, Dr. Luke files in New York a defamation case based upon the allegations of rape and drugging that Kesha claims Dr. Luke did. He claims that Kesha acted with actual malice in making the false statements about the rape, and he also claims that Kesha acted defamatorily, was acted with defamation when he says that Dr. Luke raped another female artist as well. So what's the procedural history in this case? It's very complicated. Essentially, what you have to know, simply put, is that Dr. Luke's case moved to stay Kesha's case in California, and that was granted. And while this case was pending, the SLAPP statute was amended by New York State Legislature, expanding its applicability, expanding what happens, including that if the SLAPP statute wins, if you win and you're imposing the SLAPP statute, then you get attorney's fees and other possible relief, including emotional distress and punitive damages. With respect to the holding in this case, you should know there's a majority and a dissent here, and they dealt with three primary issues. The first issue is the standard of proof that the plaintiff has to meet to prevail in a defamation case. The second is the privileges that would apply in a defamation case. And the third is the retroactivity of the SLAPP statute, whether the SLAPP statute is just proactively effective, meaning going forward, or retroactive as well, whether it applies to cases that pre-exist the effective date. The majority in this case first talked about the public versus private standard of proof. And it's important to understand that in this particular scenario, they were just reiterating what the cases have already held about this. That basically it's different standard of proof depending on whether the plaintiff, the person who's been aggrieved, allegedly by the defamation, is a public person or a private person. If it's just a normal person on the street who's been defamed, the standard is negligence. Did the person who spoke act negligently? If it's a public figure, a famous person, or a limited public figure, which is also a famous person in a specific area, the standard of proof is higher. The standard of proof becomes actual malice. And actual malice means that the speaker, that the defamer, allegedly, spoke knowing that this information was false or with reckless disregard for the truth of the statement. So the question here is Dr. Luke, who's the plaintiff in this case, a public figure so that the burden would be higher for actual malice, or is he a private figure so it would just be negligence? And in that regard, the majority says, well, for a person to be a limited public figure, he must, through a purposeful activity, he must go through a purposeful activity by which the individual has thrust himself into the public spotlight and sought continuing public interest in their activities. And the question then they had to approach is, did Dr. Luke do that? And they said, yes, Dr. Luke is a limited public figure because he describes himself in his complaint as a celebrity. He says he wrote the most #1 songs of any songwriter ever. He was named by Billboard as one of the top 10 producers of the decade. He was featured in publications and radio and media. He purposefully has sought attention for himself, his businesses, and the artists he represents, including Kesha. The second area the majority discussed is the privilege areas that may apply in a defamation case. There are essentially three different kinds of privileges that can apply. The first is the absolute litigation privilege. The second is the pre-litigation privilege. And the third is the statutory fair report privilege found under Civil Rights Law 74. And they went through each of those privileges and discussed how they may apply in this case. What you have to understand about these is that the absolute litigation privilege, according to the majority, is absolute. And that applies with respect to statements made by attorneys or litigants in connection with the proceeding that are material and relevant to the proceeding itself. And it's absolute. So regardless of motive, bad faith, good faith, it does not matter. It's an absolute privilege. So in this particular case, it covered Kesha's statements in the California complaint, in the New York counterclaims, and in the affidavit that was submitted in court in support of the application for a preliminary injunction. Those were made in the course of litigation and material to litigation, so it's subject to the absolute litigation privilege. It cannot be the basis for defamation. It's privileged. It fails in one of those elements. The second kind of privilege is the pre-litigation privilege, and that is a statement made in anticipation of good faith litigation to try to resolve it. So it's like a negotiation part of it. So if you're going to contact the other party and say, I'm about to file a lawsuit, this is what I'm going to say, and that's done in good faith, that could be the basis for a pre-litigation privilege claim. But it can be lost, according to the majority, if the defendant were able to prove that this is not a good faith litigation. So here, the majority says, the draft of the complaint that Kesha sent to Sony Music and to the defendant and to the plaintiff, and also what was sent to TMZ with a what's called an embargo agreement, where they're not going to publish it unless and until the complaint is filed in court. That was argued that was part of the pre-litigation privilege, but because there's a claim that it might be done in bad faith, it's not absolute. So that they're going to send to the jury to decide whether that actually is subject to the pre-litigation privilege. And the third privilege they discuss is the statutory fair report privilege of Civil Rights Law 74. And that says that a publication of a fair and true report of any judicial proceeding where the substance of the statement is substantially accurate is privileged. But it excludes someone who maliciously starts the litigation and then alleges false and defamatory charges. So here, when Kesha goes to the press and creates a press packet and goes on podcasts and goes into newspapers and goes on TV and talks about the rape, arguably She argued that that was part of the statutory fair report privilege, but that's going to go to the jury as to whether that was actually a substantially accurate claim, a substantial accurate reporting of the actual civil litigation that's been filed. And so it's not absolute, and that goes to the jury on this. The last part of this majority opinion talks about the SLAPP statute's retroactivity, and they say that there's a strong presumption as a matter of law against retroactive application of new laws. A strong presumption. It's presumed. And it will only be given retroactive application if the language requires it. So the first thing they say is look at the text, or if something else requires basically the application of it retroactively. Here they say because it's presumptively proactive, not retroactive, it's not going to be retroactive. It's just going to be proactive. So going forward, it will apply, but nothing going backward. There is, however, a strong dissent here by Judge Rivera. Judge Jenny Rivera in the Court of Appeals issues a dissent, and her dissent agrees with a lot of what the majority said, but has some disagreements. Basically, with respect to the SLAPP statute's retroactivity, she says, instead of it being a strong presumption in favor of it being just proactive, she says that's true. But when it's a remedial statute, there's a strong presumption that it is retroactive. And here they were amending an already existing statute. They amended the SLAPP statute that was from 1992, even though it was done in 2020. It's not a new law. It's an amendment of an old law. And because it was remedial, there's a presumption that it is retroactive, according to Judge Rivera. And she would say there's nothing to refute that presumption. So it's going to be retroactive, according to her. And she also disagrees with the majority, importantly, on the pre-litigation privilege application here. She would say, well, the copy that was sent to Sony Music and Dr. Luke, as well as TMZ, is the exact complaint that was filed. If the complaint that was filed was in good faith, because the complaint that was filed gets the absolute litigation privilege, then the exact match of it should also benefit from the pre-litigation privilege. There's nothing to say that it was bad faith. It shouldn't even go to a jury because it was obviously filed. And it's subject to the absolute litigation privilege. So Judge Rivera would also apply the pre-litigation privilege to that. And that's the case of Gottwald versus Sebert, Dr. Luke versus Kesha. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.